Hi, everybody, and welcome. I'm Leslie with the New Mexico Small Business Development Center, and I'm here with Ian Alden, an attorney practicing in New Mexico, and he's going to be presenting today on LLCs, explore the pros and cons. This is such a hot topic right now. I want to remind you that if you have questions, please don't be shy, type them into the Q&A, and Ian is going to be picking up the questions throughout the entire webinar.
Yep.
Also, yes, he will, and he does a great job of that. So if you think of anything off the top of your head, please type it in. Also, New Mexico Small Business Development Center wants to remind all of our small businesses in New Mexico about the dangers of cybersecurity, especially risk, ransomware, and risk to their data. We have a series of webinars that are available on our YouTube channel. And throughout this presentation, I will chat over the link for you to pick them up on YouTube. With all that, I'll turn it over to Ian Alden.
Thanks so much, Leslie, and welcome everyone to another webinar. Today, we're going to be talking about limited liability companies, the pros and cons. Before we jump into that, we'll do some basic housekeeping here. There are a number of very useful resources for businesses related to COVID-19, to maintaining a COVID-safe workplace. We all have heard about the Delta variant sweeping through the lands right now, and it's as important now as it was back then to make sure that you're doing what you need to do to maintain a COVID-safe workplace. So be sure to check out some of the resources that are available to you here. You should be able to get a copy of the slides after the presentation. Some other housekeeping stuff. Your microphone should be muted by default, but if not, make sure it gets muted. Make sure your Zoom ratio is set to fit window if it's not already. That way you can see all of the slides. As Leslie mentioned, we're going to be using the Q&A function to take questions throughout the presentation, so don't feel like you need to hold on to the end. If you have a question, just jump right in. Now, I'm not going to be checking the chat window, but I will be using Q&A, so make sure your questions go there. If you do decide you want to hold your question till the end, just make sure you write down your question and the slide number that it relates to. You can see the slide number in the bottom right-hand corner of the screen. So just so you're made aware, there's a number of other great workshops and webinars coming up in the next few days and throughout the coming weeks and months. Coming up this week, we've got 7 powerful offline methods to promote and grow your business. Cash is king, cash management strategies, debt collection strategies for small businesses, and are you tax ready? How to deal with the Paycheck Protection Program, economic impact disaster loans, ERTC, all the stuff that's come up in the last year, the COVID stimulus relief measures, all these different tax programs. It's important now that we're getting into tax season to really know how you're supposed to deal with that going forward. So be sure to go to nmsbdc.org to check out and register for those and a whole bunch of other great workshops and webinars coming up. And also you can request no-cost business counseling and loan application assistance. I mean, a lot of great resources at your disposal there. So be sure to head to the website and see what's on offer. A quick disclosure. Everything I'm presenting here is for informational purposes only. It does not represent specifically tailored legal advice. There's no attorney-client relationship here. I'm just giving you some helpful hints and information. Highly recommend that when it comes to your own situation and your own strategies and planning, that you consult with a good professional advisor, which again, go check out the SBDC's no-cost business counseling services. That's a great first stop. So we're going to talk about LLCs, and I'm going to be talking about the pros and cons of LLCs throughout. But in looking at LLCs, it's really important to understand what the alternatives are and what limited liability companies are really meant to do for you and to replace and to make easier. So we're going to look at some of these other entities, some of these other use cases, and then really drill down on why LLCs are beneficial and how you can strategize and use them properly. Not sure where point number 2 went there, but it's going to be 1, 2, 3, 4. So we'll talk about really how you can make effective use of LLCs and how you can really strategize beyond just having an LLC. There's lots of great ways to use them strategically for your advantage. But before we jump into that, I want to look at sole proprietorships, because this is like the default, what am I upgrading from use case. Now, here's a quick and easy example. Joe opens up an automotive repair shop that he owns and that he alone owns. He doesn't form an LLC, he doesn't form a corporation. He just picks a name, what he calls a DBA, and runs it. So Joe's Automotive Repairs, for example, that's just his doing business as. What Joe has right there is a sole proprietorship, which the IRS defines as someone who owns an unincorporated business by himself or herself, but that's not really the whole picture. If you have an LLC, you're not technically sole proprietorship in the eyes of the law. If you have a corporation, you're not. If you've got a partnership, well, that's you and someone else. But the point is, the sole proprietorship is really just you on your own without any kind of corporate or other legal business entity doing your thing. Now, as this might all suggest, it's pretty darn simple to run a sole proprietorship. You're not really doing anything. You're not filing any paperwork. You're not really forming anything. Legally, you are the business. There's no distinction. It's you, Joe, so-and-so, doing business as Joe's Automotive Repairs. So there's the pro, if I had to pick one, is that it's simple. You don't really have to do much to start one. You can operate with your own social security number if you want, though there's reasons where you might be required to get an employer identification number, like if you hire employees for your sole proprietorship, which I'm just going to kind of shortcut this here and say don't have a sole proprietorship, because the big glaringly obvious con for sole proprietors is there's personal liability for the owner. If you own a sole proprietorship, you and the business are the same thing. So if the business harms someone, if it breaches a contract, if someone slips and falls at the business's facilities, if it fixes the vehicle incorrectly and it explodes, I mean, you can go pretty crazy with these hypotheticals, but the owner of the business is personally responsible for the debts and obligations of the business. So it's not some LLC that's getting sued. It's you personally, which means a sole proprietorship is, and I cannot stress this enough, a very bad idea. I'm not dedicating a lot of time in this presentation to sole proprietorships. I just want to make the point that this is kind of the traditional base use case that you upgrade from when you start an LLC. Last, and I know I've already mentioned this, but the owner's personal assets can be seized to satisfy judgment against the business or to pay its debts. So if someone is harmed by Joe's Automotive Repairs, they're suing Joe personally, and they're going to go after his home, his cars, his bank accounts, his future income through wage garnishment, tax returns and refunds, retirement accounts, you name it, like, except for whatever the law says he can protect, which isn't much. Judgment exemptions aren't exactly big dollars. His personal assets are on the chopping block. So that's sole proprietorships in a nutshell. And so we talk about LLCs. Again, it's important to understand what the alternatives are so that you can understand why an LLC might be advantageous for you over those alternatives, the pros, or why you might go with something else like a corporation or a partnership. I'm going to talk about the cons as well, because there are some, and it's really important to understand what your options are and where you might say, hey, maybe the LLC isn't the way to go here. Maybe I really need a partnership, or maybe I really want a corporation. So without further ado, I'm going to start with corporations. Now, when you think of corporations, you typically think of the profit corporations. There's a few other types that I'm not going to spend a ton of time here talking about because they're just not relevant alternatives here. But profit corporations, they are your small business corporations, your SCorps. They're also your behemoth large corporations. large multinational banks and that sort of thing. They are the old school business entity. They, limited liabilities came about in the 1970s. We've had corporations a lot longer than that, following back to the colonial days and Great Britain. Corporations and corporate charters have existed for hundreds of years. So they are kind of the traditional business entity that people used to form, especially back before LLCs became a thing. Just to drill down on some terminology, corporations have articles of incorporation. You get it? Incorporation. It's helpful when you're trying to remember these things. If it says incorporation, we're not talking LLCs. We're talking corporations. So they've got their articles of incorporation, governed by the Corporations Act. Corporations have shareholders, directors, and officers. Shareholders are the owners of the company. Directors are appointed by the shareholders to, on a high level, manage the company, and then officers are appointed by the directors on a low level to manage the company. Shareholders begets directors, begets officers. Pretty simple or straightforward when you actually look at one in practice, but it's a lot to wrap your head around initially. Probably the more important takeaway here is that you've got corporations that come in two distinct tax flavors, C Corps and S Corps. I'm going to talk about each because for LLCs, there's this thing called check the box taxation. You can choose how you want your LLC to be taxed. And I cannot stress this enough. That's one of the biggest strategic advantages of an LLC. So definitely pay attention and take some mental notes or some actual notes when I go over the differences between C Corps and S Corps, because you can have your LLC taxed as either, and that can create some huge, huge tax advantages for you if you do this right. So real quick, the other types of corporations, I said I wouldn't spend a lot of time on them, but it's worth knowing. There's the nonprofit corporations, which are the foundations for 501c3 organizations. Basically, you start a state level nonprofit corporation, and then you apply to the feds, to the IRS for 501c3 recognition. Nonprofits, they don't really apply here. If you want to start a nonprofit venture, probably looking at a nonprofit corporation, because LLCs don't work particularly well for 501c3 or nonprofit activities. They kind of can, but it's really you're making a lot more work for yourself than you need to. So if you're looking at a nonprofit, you're really not looking at LLCs anyway. You're looking at nonprofit corporations. The other type of corporation is a professional corporation, which is just a profit corporation for licensed persons. It used to be in the olden days that if you were a lawyer or a doctor or a dentist and you wanted to start a business, you had to start a professional corporation. There were subsets of corporations that were designed specifically for these licensed individuals. And the big difference is just, if you have a professional corporation, you need the shareholders to be licensed to provide the professional services that the company provides. So you can't have a non-lawyer owning a professional corporation law firm. You can't have a non-doctor owning a professional corporation medical practice. That's the long and short of it, but otherwise they're functionally profit corporations. So getting into kind of the meat and bones here, corporations can elect to be taxed as C Corps or S Corps, subchapter C corporations or subchapter S corporations. There's some big differences between the two, and there's ways to use these strategically, and there's some reasons why, especially with C Corps, we're going to hit on some cons of LLCs that might lead you to have a C Corp instead. Now, C Corps, they are your oldest of the old. They're your traditional double tax entities. When you think of big multinational banks, they're probably taxed as C Corps. When you hear of a company that issues dividends, they're taxed as C Corps. Basically, a C Corp, it's a double tax entity. The corporation brings in money. It pays tax on that money at a corporate income tax rate, which used to be 36% before the tax reform law a few years ago. Now it's 21% at the federal level. So the company pays corporate income tax on its money, and then it holds the money. It belongs to the corporation. There's no rights of the owners or shareholders to that money. The corporation sits on it. It can either reinvest that money, spending it on new things for the business, or it can pay that money up to the shareholders in the form of a dividend. A dividend, once it goes to the shareholders, is then taxed to the shareholders at their dividend rate, which is typically up to 20%. That's the double taxation. The money that goes into the corporation gets taxed, but when it gets paid to the corporation pays its corporate income tax. Then it gets taxed a second time when it gets paid up to the shareholders as a dividend. Double taxation. When the corporate income tax rate was 35%, that was a monstrous tax hit. I mean, you were looking at 35% and then 20% on top of it, functionally 50-ish%, not including state level taxes. I mean, just 50% corporate at the federal level. With the tax reform law, it's become a lot less onerous. In fact, it oftentimes balances out to the same as personal income tax rates at the highest margins. Sometimes it beats it. Sometimes, depending on your tax rates personally, especially if you're dealing with reinvestment where the company is going to pay 21% on its money and then reinvest it, that can be a lot better than if the money is being passed through to the shareholder, taxed at 35%, and then reinvested. There's ways to use C Corps strategically, is what I'm saying here, especially with the tax reform law. So that's a C Corp in a nutshell. We'll talk about the S Corps and then some quick differences about them. But it's important to know that C Corps are a double tax entity. None of the other ones we're going to talk about are. Everything else is what's called a pass-through entity, which means the company doesn't pay any tax on the money it receives at the corporate level. There's no corporate income tax on a pass-through entity. Instead, the profits and losses pass through directly to the owners, and the owners are automatically assigned that money for tax purposes. So if the company makes $100,000 a year, the owners are automatically assigned that $100,000, and they have to pay taxes on it at their personal rates, which go up to 35-37% federally. So there you have the big advantage of C Corps right now. If the corporation is reinvesting its money, it's better to pay 21% tax on that money than 37%. But all of the other stuff, including S Corps, are pass-through entities. So we look at S Corps. These are often referred to colloquially as small business corporations. There's no double taxes. Everything just passes through to the shareholders, taxable to the shareholders. One of the big things about these S Corps is that the owners have to be employed by the S Corps if they're providing any kind of services for the company. And so the shareholders are going to have a mix of W-2 income from their reasonable salary, and they're going to have a net business income, K1s, from the company's net business income. So S Corps, there's some restrictions on S Corps. You can only have up to 100 owners, can't have any non-resident alien owners, can't have more than one class of stock. None of that is true for C Corps. They can be foreign owned. They can have as many classes of stock as they want, by and large, with different rights for each. There's common stock, preferred stock, Class A, Class B. Some stock gives preferred rights for dividends. Some stock gives preferred rights for liquidation proceeds. S Corps, you only have one class of stock. And so you look at the big differences, why you would use each. I already talked about C Corps and why you use them. S Corps, the big draw for an S Corp is sometimes you really don't want that pass-through taxation, you don't want the double taxation of a C Corp, especially if you're not reinvesting the money. Maybe you're providing services and you're not trying to grow the company. You just want your money without paying double taxes. You want to pay as little in tax as possible. Maybe a subchapter S Corp with its pass-through taxes makes more sense for you. Again, have to be paid a reasonable salary. Salary is subject to the payroll deductions, but it's the income above and beyond the salary is not. So you don't pay Social Security or Medicare tax on the S Corp income above and beyond your salary, which is a big big tax advantage for S corps, and it's the biggest reason why people use them. So again, let's stop and take a breather, because we're here to talk about LLCs, not corporations, right? Circle back here, everything that we just talked about, your LLC can be taxed the exact same way. So let's say you want to have an LLC for one of the many reasons we're going to talk about: anonymity, simplicity. You don't have to do any of the corporate formalities. You don't have to do annual meetings or minutes, or typically you don't even have to do annual reports for an LLC. They're very simple and easy to form and easy to manage. But let's say you want that simplicity, you want the anonymity we'll talk about later, but you still want CCorp taxation, because you don't, you're going to be reinvesting all the proceeds of the business, or most of them. So you want to pay that lower tax rate at the corporate level. You can make your LLC taxed as a C Corp. Or let's say you own an LLC, you want to be employed by it because you're going to have a lot of income, you're going to be able to do the reasonable salary, and you want to save as much as possible on Social Security and Medicare taxes. You don't want to overpay, and so you want to split the company's income between your salary, which is subject to Social Security and Medicare taxes, and everything else, which is not. Cool. That's the big draw of an S Corp. You can have your LLC taxed as one. And most folks, well, a lot of folks do, especially after the first few years. Once the LLC is established, they say, hey, I'm paying more in taxes than I need to. Let me go with the S Corp election. And so when I'm talking about all of this stuff, I want you to look at it through the lens of an LLC. How can this benefit me? So that's corporations in a nutshell. The big drawbacks, again, that I talked about, corporations, they can be kind of unwieldy, they're big. You have all these formalities, you got to file stuff with the state on an annual or biannual basis. You got to have annual meetings, keep minutes, keeping up with the Joneses, as I like to call it. You've got to keep up these formalities. And then you've got, again, shareholders, directors, and officers. It's the three-layered system. Maybe you want something simpler. LLCs are simpler, and we're going to talk about that in a sec. But the other type of business that you could form in lieu of a corporation or an LLC is a partnership. A partnership, it's just an association between two or more people to carry on as co-owners of a business for profit. It's an incredibly informal arrangement, in that it's very possible, and in fact, there's a lot of fun lawsuits about this. You can have a partnership between two or more people or companies or whatever without ever intending to. If you have some kind of a business arrangement that's not memorialized in some way that says this is not a partnership, you may have inadvertently created one, which, partnership, it's an ongoing business relationship. And a lot of people don't want a partnership for reasons I'll outline. So, when you have B2B or business to business arrangements, contracts, etc., there's almost always a clause in there that says the parties do not intend to form a partnership. This is why you see that clause. And when you're dealing with those contracts, and this is a bit of a digression, but if you have a contract between your business and another business, or between you and the business to do something, and you don't see that clause that says we're not meaning to make a partnership, you might want to check and see if you should add it. But that's a partnership in a nutshell. You don't register it with the state, at least in this state. Some states make you, but actually you can have partnerships in pretty much any state without registering, but you don't register it with the state. There's not necessarily a formal document that creates the partnership. I mean, if you really intend to make a partnership, you might have a partnership agreement, but you can pretty willy-nilly make a partnership. They're pass-through entities, just like S Corps, just like sole proprietorships, which, by the way, are pass-through entities. All the profits and losses of the company pass through to the owners and are taxable directly to the owners. Partnerships, sole proprietorships, S Corps, those are the big three pass-through entities. So it all passes through to the partners. Partners get their K1s at the end of each year, showing their share of partnership income. A big difference between partnerships and S Corps is partners cannot be W-2 employees of the partnership. You can have an arrangement where one of the partners is providing special services and getting an extra cut of money before the partners are paid anything generally. Those are called guaranteed payments, but it's not the same thing as salary. Partners cannot be W-2 employees of the partnership. And that goes for LLCs as well. If you have an LLC taxed as a partnership, because remember, your LLC can be taxed as anything. The owners of the LLC taxed as a partnership cannot be W-2 employees. That's another big reason why a lot of LLCs elect to be taxed as S-corps over partnerships, is because, again, with S-corps, the owners are W-2 employees. They pay Social Security and Medicare taxes on their W-2 income, their salaries, but all the income of the company above the salary level is not subject to Social Security and Medicare taxes. With a partnership or an LLC taxed as one, all of the money that comes in, the net business income, is subject to Social Security and Medicare taxes, at least up until you hit the Social Security cap, but then you're still paying Medicare taxes. So big difference between partnerships and S-corps when you're figuring out with your LLC, what do I want it to be taxed as? Keep that in mind. The big disadvantage of partnerships, huge, monumental, mammoth disadvantage that makes me say in 9.9 out of 10 cases, use an LLC instead of a partnership. Partners are directly and personally liable for the liabilities of the partnership. Each partner is jointly and severally liable, which means if you've got 5 partners and a big debt of the partnership and 4 of them disappear into the wind, the remaining partner can be on the hook for 100% of that debt, because the creditor can go after whoever they can get at for the entirety of the debt. There's some variations of partnerships that try to limit the liability. There's limited partnerships, there's limited liability partnerships, there's limited liability limited partnerships. They all play on a theme of trying to limit the liability of some of the partners, but invariably not all. There's typically always a general partner who's going to be on the hook for these things. And so, with the advent of LLCs, partnerships have largely fallen out of favor. So at long last, we're going to talk about limited liability companies. LLCs, here's the primer. They're governed by, in this state, the New Mexico Limited Liability Company Act. It's a subset of our corporations laws that deal specifically with LLCs. They were first invented in the late 70s. So these aren't well-aged entities. They're pretty recent in the grand scheme of history, which is why the IRS still doesn't quite know how it feels about them. And to get a sense of that, go and look at the guidance for, do I need a new EIN? The IRS makes it very clear that they threw up their hands when the states invented these LLCs and said, we don't know what these things are. We're not going to try and figure it out. We're going to let LLCs pretend to be whatever they want, subject to some limitations, which is, again, the check the box election. So if you make an LLC, the state views it as a limited liability company. You get all of the fun LLC protections that I'm about to talk about. But for tax purposes, when you form an LLC, the IRS sees it as something completely different. Here are the general rules. If you have an LLC that has one owner, by default, it's taxed as what's called a disregarded entity, which is literally the same thing as a sole proprietorship. You can have an LLC, but for tax purposes, the IRS is going to think of it as a sole proprietorship, which means the simplicity of taxes that you get with a sole proprietorship, you get with that LLC, which is just, you report all the profits and losses of your business on your personal tax return, your Form 1040, Schedule C and Schedule E each year. It is remarkably simple to report the taxes for your sole member LLC if you do that. And so that's a big advantage of an LLC over a sole proprietorship right there. You get all the protections of the LLC we're about to talk about, but the same simplicity of administration, the same simplicity for taxes. So there's no reason in my book to ever have a sole proprietorship in lieu of an LLC. But let's say you have more than one owner. Well, first, let's say that you don't. let's say you've got that sole member LLC, but you don't want it taxed as a sole proprietorship. Let's say you want to be a W-2 employee so that you can get those tax benefits I mentioned. You can elect to have your sole member LLC taxed as an SCorp. Or let's say you want the CCorp level 21% taxes, you're going to be reinvesting and growing the business. You can elect to have your LLC taxed as a CCorp if you have one owner. The only thing it cannot be taxed as is a partnership, because a partnership, again, is a business with 2 or more owners. So you cannot have your single member LLC taxed as a partnership. But, again, let's say you have more than one owner. The LLC is going to treat, or the IRS will treat your LLC as being taxed as a partnership by default because it's a business with 2 or more owners. So you've got the LLC, you've got the limited liability protections for the owners that we're about to talk about that you absolutely did not have with a partnership. But for tax purposes, the IRS still treats it as a partnership. But then you can turn around and elect to have it taxed as a corporation, a C Corp or an S Corp. The only thing you can't have a multi-member LLC taxed as is a disregarded entity, sole proprietorship. If you have 2 or more owners, by default, it's a partnership. 1 owner, it's a disregarded entity, sole proprietorship by default. So that's the big flexibility with an LLC. The IRS thinks of it as one of these other things, but the state still sees it as an LLC. So let's look at what that really means. An LLC has members as opposed to shareholders. There's no shareholders, there's no directors. It's not a 3-tiered system here. You've got members and officers. You might have managers. You might make a 3-tiered system where you have members, managers, and officers. You might just have members and officers, or you might just have members and managers. It's such a highly customizable business entity that you can really go nuts here, subject to certain limitations that have to do with tax law. For example, you can't, if you have an LLC taxed as an S Corp, those shareholder restrictions I mentioned still apply. So your LLC can't be owned by more than 100 people, can't be owned by any non-resident aliens, can't be owned by other corporations or partnerships. You still have to keep within the confines of the tax system. So however it's taxed, those regulations still apply. But otherwise, you can really go nuts with the customization. You can create units, which are like measurements of ownership as opposed to shares, or you can just use a percentage system saying so-and-so owns 40%, so-and-so owns 60%. We're not getting any more complicated than that. I mean, really, LLCs are nice because they're flexible. They're also very informal. Like I said, with corporations, you've got the annual or biannual reports. You've got the annual meetings you're required to hold. You've got to keep minutes. You've got to keep a stock ledger. You've got to do a lot of basic formalities with a corporation that you don't have to do with an LLC, which means it's much simpler to administer. In this state, and this varies state by state, but in the state of New Mexico, if you form an LLC, there's no annual report obligations unless it's taxed as an S Corp or a partnership, in which case you might have some state level tax disclosures, but there's no annual report you have to file with the Secretary of State, which means you form the LLC and it just exists in perpetuity. Nice and simple and straightforward, which is why you might go with an LLC over a corporation. And again, it's got the liability protections for the owners, which is that the owners are not liable for the debts and obligations of the LLC, except to the extent of their investment, which means someone sues the LLC and gets a judgment. Assuming you ran the LLC properly and there's no grounds to pierce the corporate veil, someone who gets a judgment against your LLC can go after its assets. Any money you put into the LLC is effectively gone. I mean, they can go after that money or the assets or whatever. But beyond that, the owners are not personally liable. They can't go after the owners to, try and take their homes or their vehicles or their retirement accounts, et cetera. That's the limitation of liability, which makes it that much more attractive than a partnership. There's one reason here. Let's see where we are here. Again, for sole proprietors, it's a no-brainer. Make an LLC. There's no reason I can point to why you would be a sole proprietor instead of the owner of an LLC. For partners, same thing. The only reason you would use a partnership instead of an LLC is if you have a business-to-business arrangement of limited duration, meaning I've got business A, so-and-so has business B. We don't want to start a limited liability company, which, has its own sort of formalities. You've got ownership, you've got an operating agreement that governs that as a separate company. We just want to get together to do this one thing and then go our separate ways. In that situation, you might want to have a partnership between the two LLCs, because even though each LLC as a partner would be liable for the debts of the partnership, each LLC still exists to protect the individual owners. So there's no direct liability of the owners for the debts of the partnership. The liability still stays with the LLCs that are partners. And so for business to business arrangements, you might use a partnership in some cases, but by and large, LLCs have made partnerships a bit of a relic. I mean, I very rarely see a partnership or do a partnership anymore. It's only in those situations I mentioned. The big reason you might use, first, S-corps. LLCs can be useful alternatives to S-corps because you get the same tax treatment without the formalities of state level filings, repeated filings and that sort of thing. The same limitations can apply, and you get the anonymity not available to corporations, which I'll talk about in a second. So anonymity is a big draw of some LLCs if you set them up right, and you don't get them with corporations. You do not get them with corporations. There's always something disclosed in the Secretary of State, whether that's shareholders, directors, etc. It's difficult, if not impossible, to have an anonymous corporation, but you can make anonymous LLCs pretty easily. So LLCs can be a useful alternative to S-corps. C corporations, this is the one instance where I'm going to say you might want a real C corp instead of an LLC. Because while LLCs taxed as C corps are nice if you want the anonymity, which I'm about to talk about, you get the same tax treatment if you make your LLC tax as a C corp, except for two things. One, if you're going to bring on investors, which a lot of the owners of C corps like to do, I mean, eventually, even if you're not going to go public, you might bring on an investor class, private equity, etc., who's going to put money into the company. They're going to want preferred shares that entitle them to first dibs in the event the company goes under. They want to get at the liquidation proceeds before the founders. And so you can do that with a C corp or an LLC taxed as one. You can create multiple classes of shares or units. But what you don't really get with LLCs is the true protection of the Corporations Act for shareholders. Investors will by and large insist on real C corps instead of LLCs because different acts apply. The Corporations Act applies to corporations, the LLC Act applies to LLCs. The Corporations Act goes into a lot more depth with respect to investors and investor rights. So investors will prefer real C corps. And there's this thing called qualified small business stock, where if your business is worth less than $5 million at its inception and you hold it for 5 years, you can sell the stock and write off, if you meet the qualifications, like 50% of the capital gains. It can be a huge tax savings, huge tax savings. I mean, 50% of your gains, tax savings. You can get that when you're selling stock in a C corp. You cannot get that when you're selling interest in an LLC taxed as one. So if you're going to have your entity taxed as a C corp, you might want a real C corp. There's a con of LLCs, but otherwise LLCs are solid. Let me answer the Q&As. So I've got a question in the Q&As. I'm not going to read the names or anything. I wish I had known all I've learned today before I actually started my business. I registered as a sole proprietor. I definitely need to change to an LLC. Where would I begin? So that's a great question. And I will say it's never too late. I mean, for liabilities that cropped up before the conversion, or if there's a lawsuit while you're still a sole proprietor, it's definitely too late. But, it's never too late to start to adopt best practices. And so what I would say is you form an LLC. You contribute your existing business interests into the LLC, which includes any assets used by the business, equipment, machinery, etc., intellectual property and intangibles, so the name of the company, the goodwill, etc. You're basically taking all the business that you personally own and you're contributing it into an LLC that you start. Then from there, you stop doing business as the sole proprietor. I mean, there's a hard cutoff, and you start doing business as the LLC. You get the EIN for the LLC. You tell people in future contracts, you're an LLC now. You report it on your website, you're an LLC. You just have that line in the sand, and then from there on, you're an LLC. And so at least with respect to future potential liabilities, you're protecting yourself. So it's never too late to adopt best practices. So that's really where you would begin. You'd start the LLC, plug the business into it, and then just carry forward.
And Ian, do you have the link where they file for an LLC? Do you have that in the slideshow?
I don't have the link for it. It's done with the Secretary of State's office. And so they've now taken to doing this online, where you can go to the New Mexico Secretary of State and go to form an LLC, and you can do that online. I'm not going to plug my own firm. You know, we do those, so do a number of other good attorneys and businesses throughout the state and country. So there's all kinds of filing services that will help you if you don't feel up to making the thing yourself. Otherwise, you can always e-file to create your LLC, at least in New Mexico, online with our Secretary of State. So follow up with that same person. I'm going to touch on some other questions that are coming in. I haven't quite started yet, but I have the state and federal number. I'm not sure what that number is exactly, but when you file the LLC, you would need a new one. You need a new federal employer identification number for that LLC, which you would in turn use to get your state's ID. It used to be the CRS ID, and now it's like the business tax ID number as of a few weeks ago. And then you'd get the bank account and the name of the LLC and carry on, but you would need those numbers brand new for the LLC. Getting lots of questions. Awesome. So next question. I'm a member owner of an LLC registered in the state of Colorado. The FEIN was assigned in 2007, and I recently moved to New Mexico. Can I maintain the Colorado entity and do business here? And the answer to that is you absolutely can. What you do is you register the LLC, the Colorado LLC in New Mexico as a foreign LLC. And what that means is, you know, an LLC is a distinct legal entity. It's its own thing. It exists, it has its own legal identity, but it's based in a state, in this case in Colorado. So when you register it as a foreign entity in another state, it's one entity, it's one legal thing, but it exists in two places at once. So you do that in New Mexico, and there you have it in Colorado and New Mexico at the same time. If you want to just move it to New Mexico and not have it registered in Colorado anymore, you can. That's a process called, you know, it could be a different thing, domestication, merger. It's a relocation, and it's doable. It's a little tricky in New Mexico, but it's something you could do.
I also chatted over the link in the chat to Secretary of State's website. Anyone can click on that and get the link. We've got a lot of questions coming in.
We sure do. Wow. Okay. So next question, and sorry if I'm taking these out of order, but I will get to them all. Is there a recommendation of income level to determine if an LLC or SCorp would be best? What I would say is, you know, I'd probably go with an LLC taxed as an SCorp, unless you have a real reason for a real SCorp. But the question is usually, I've got this brand new LLC. If it's just me, it's taxed as a sole proprietor, disregarded entity. If it's me and someone else, it's taxed as a partnership. When would I want to have that stay as, you know, disregarded entity or partnership, or when would I want to have it taxed as an SCorp? Do I have a recommendation on income level to make that choice? And the answer is actually yes. The big requirement for an SCorp is that the owner be paid a reasonable salary. There's a window washer coming down my tall building right on my window, so sorry if I'm a little distracted. again, S-corp owner has to be paid a reasonable salary from the get-go. As soon as you declare as an S-corp, you have to be paid that salary. So I tell people starting a new business, if you're not going to have steady and reliable income in your first year or two to pay yourself that salary, don't make the S-corp election, because it can create a lot of headache and complications if you can't pay yourself the reasonable salary you're owed. So when should you make an S-corp election? I usually suggest after the first year or two. That way, you've got your LLC, it's taxed as something where you're not paying yourself a salary, but you're getting your cut of the money the company makes without the salary obligation. And then once you're a few years in, you say, okay, I'm going to save a lot in taxes now that I've got consistent income. If I do the S-corp election, you can make it then. And so that's probably my recommendation for strategy. And it's a good strategy to consider. I, along with the relative, own a commercial property. Once we pay the property off, we would like to transfer the ownership of the property to an LLC. How would having the property owned by an LLC benefit us? Great question. A lot depends on if you're using the commercial property for commercial purposes or if you're leasing it out to someone else. If you're owning it and leasing it to someone else, your exposure isn't huge, but it is a thing where, if someone gets injured on the commercial property, they're going to sue everyone. They're going to sue the business that was operating on the property, and they're going to sue the owner of the property. And then it's up to the courts to say, well, the owner of the property didn't really do anything. There wasn't a hazardous condition they should have known about or fixed, so yada, yada. But you're still personally in that lawsuit, and there's a risk that you could lose it. So you don't want to find yourself in that position. You put the commercial property in an LLC, and then again, if you're leasing out to someone else to use for their business, you lease it from your LLC to their company or whatever, and then you're protected in that sense. If you're using the commercial property, it's a no-brainer. Put it in an LLC, because then, again, the business activities that you're carrying on, if you're carrying them on as a sole proprietor or partnership or whatever, that's personal liability for you. So in any variation of these facts, I'd put it in an LLC. Another question, can you explain piercing the corporate veil? This is a fun one. Basically, if you have an LLC or a corporation, it creates a limited liability buffer for the owners. The owners aren't directly liable for the debts and obligations of the company, but there's an exception to that. It basically boils down to mismanagement of the company. Let's say so-and-so gets a judgment against your LLC, and your LLC doesn't have the money, the resources to pay that judgment. The judgment creditor, which is the injured party, can go to the court and say, Your Honor, they don't have the money to pay me. In the interest of fairness, I would like to go after the owners of this company to satisfy the judgment. And there's 3 criteria in New Mexico that would let someone pierce the corporate veil. The first is commingling of assets. If you are using the LLC's assets for personal reasons, you're paying your mortgage, you're paying your Netflix bill out of the LLC's bank account, or vice versa, if you're paying the company's expenses from your personal bank account, that's a commingling of assets. That lets the court say, okay, you are treating this LLC as an extension of yourself, so I'm going to let them go after you personally because you've commingled the assets. The second is what's called the alter ego or instrumentality rule. And what that means is, if you have an LLC and you're using it for a bunch of different, completely unrelated things, and the only common factor is you personally, the court can say, this LLC is just your alter ego. You're using it for whatever. It doesn't exist for a real business purpose. So I'm going to let them go after you personally for the judgment. The third is what's called undercapitalization. And this takes one of 2 forms. If you deliberately drain the LLC's bank account such that it cannot pay its regular expenses, its lease payments, et cetera, that's a form of deliberate undercapitalization. The court's going to look at that and say, okay, go after the owners with my blessing. The second, which really trips people up, is gross undercapitalization. If the LLC does not have enough between cash on hand, assets that can be liquidated, and insurance policies to satisfy a reasonably foreseeable claim against it. That's a sort of undercapitalization where the court might say, okay, in the interest of fairness, you can go after the owners here. And an example of that is, let's say you run a facility, construction site, someone gets injured on the job, or someone wanders onto the construction site and gets injured by some kind of hazard or another, and you don't have commercial liability insurance or whatever insurance is going to cover it. Your company's not going to be able to pay $1 million judgment probably. So they're going to be able to go after the owner personally. And the best practice here is just when you have a business, make sure that you are not commingling the assets. Make sure that you're using the LLC for one specific business purpose. Don't have a bunch of different businesses in the same LLC. Make sure that you leave some money in the bank account to pay the LLC's expenses, and make absolutely sure you've got good insurance in place to cover the reasonably foreseeable claims against the LLC. Figure out what those claims might look like based on your business activities. Talk to an insurance broker and get the policies in place so that you can demonstrate to the court, Your Honor, I did everything commercially reasonable to have the resources to pay this claim. That's piercing the corporate veil in a nutshell. Next question, are the directors of a corporation the owners of that corporation? And the answer is they can be, but they don't have to be. Typically, if you have a corporation that's small, that's held by just a few owners or shareholders, they're going to be directors as well. And they're also probably going to be officers. You're probably going to have the same 1 or 2 or 3 people be the shareholders, the officers, and the directors. But that, it doesn't have to be the case. You can hire or appoint directors who are not also shareholders. And you can have officers who aren't shareholders or directors. They're just employees of the company. There's all kinds of ways to do this. But you typically need those 3 things, shareholders, directors, and officers for a corporation. Last question I've got right now, in an LLC with 3 members, can one member who does most of the work draw a salary with a W-2 while the others do not? And the answer really depends on how it's taxed. If, for example, it's taxed as a C-Corp, the answer is typically yes, with a few limited exceptions. If the answer is an S-Corp, the answer is no, unless those other shareholders are doing literally nothing. If they are pure passive investors, then there's no reasonable salary to be paid because they're not doing anything. But if it's a situation where someone's doing 90% of the work and then you've got 2 other owners who are doing 5% each, you still need to be paid a salary in an S-Corp context. If it's taxed as a partnership, again, no one's paid a W-2 salary. What you might have there is the one owner who's doing all the work gets guaranteed payments, which get paid out to that person for any money gets split up between the partners based on their ownership interests. So that might be a situation you look at. It all depends on how you have this thing taxed, but there are ways of doing it to balance it out in the interest of fairness. So I've explained why you would use a C-Corp in lieu of an LLC, but otherwise, by and large, I recommend LLCs. I mean, they tend to be better, more flexible than their alternatives. But one big advantage to LLCs you don't get elsewhere is anonymity. There's a handful of states, New Mexico is one of them, that support anonymous LLCs, which all they really are is LLCs whose ownership information is not made publicly available in the Secretary of State database for the state in which the LLC is filed, which means you go look up a New Mexico LLC, and unless the owners voluntarily disclosed who they were in the filings, which is not a requirement here, unless they did that, you won't be able to see who owns the company. There's ways to extend anonymity to all 50 states, whether it's by parent-child holding companies or whatnot. There's ways to do it in all 50 states, but it's a feature unique to LLCs. So, if you search for an LLC that's anonymous in the Secretary of State database, you can't see who owns it. And you filter that down a little. If you have real property, real estate owned by an anonymous LLC, you search the property and the property records, and you're not going to see who owns it because it's owned by the anonymous LLC. That gets recorded in the title. You search for the LLC and you're not going to see who owns it. So anonymity is a really neat feature of LLCs that you do not get with corporations. You kind of get it with partnerships because you don't have to register them, but corporations, no anonymity. LLCs, yes. Now, keep in mind, anonymity does not extend to tax entities. The states typically know who owns the company. The banks, lenders, financial institutions know who owns the company. It really is just a broad sort of anonymity from the general public. But it's a neat feature of LLCs. Again, there's ways to do this in all states, whether it's through stackability, et cetera. But that's anonymity, and it's really kind of a neat feature. One of the biggest sellers that we provide is anonymous LLCs. Like I said, I'm not plugging my firm. A bunch of people do this, but it's a neat feature of LLCs. So let's cover some basic strategies for using LLCs effectively. The first is plan ahead. We already saw in the Q&A, maybe you didn't plan ahead. Maybe this is all new to you, and that's fair because not everyone is going to know all of this stuff. It's just, you're not, like I'm a lawyer. That's why I know this and provide this info to you. But to the extent you can, plan ahead, whether that's using your professional resources. Again, the SBDC no cost business counseling is a great first step, but plan ahead because it's really hard to correct things if you do them improperly. For example, if you don't make the LLC correctly to grant yourself anonymity, it's often impossible to get anonymity after the fact with a corrective filing. Another strategy is holding companies and sibling LLCs. If you've got real estate that you rent out, let's say you've got 5 rental properties, have a holding company, and then beneath that holding company, have 5 LLCs, one for each rental property. If an LLC costs between $50 and $300 on average, depending on the state and choices, and your property costs $200,000 to $300,000, it's a no-brainer. Spend the $300 or whatever to protect your investment. 1 LLC per property. That's just a good strategy for limiting your liability even further and using LLCs to do it. Because again, especially if you don't have an annual report that you have to file for the LLCs, it's just a nice and simple structure to create. Don't forget about the taxes. We talked about the different options for tax structures here. Make good use of a CPA or tax attorney when you're planning these things. A good CPA is worth their weight in gold, and it really helps to get a relationship with one earlier rather than later. Also, you want to plan for multiple phases of your business. When you're in startup mode, you're probably not thinking about, well, how do I sell this business or retire? But like with qualified small business stock, as I mentioned earlier, if you plan ahead, even if it's just a few years, you can really do yourself a favor down the road because, QSBS, if you're writing off 50% of the taxable gains when you sell your business, you're going to be thanking yourself you did that prior planning. And again, splitting them up, siloing liability, it works for rental properties. It also works for multiple business locations. If you have multiple business locations, there's ways to put them under separate LLCs, and there's ways to do it in such a way that you share the name amongst them. So in the eyes of the customer, there's no real difference. But for you, you've separated out the liabilities of each different business location. So there's ways to use LLCs in kind of a meta way to really limit your liability even further than just having one. And last bit of advice here, don't overcomplicate things. I've seen people who started 40 LLCs in a go for things that they planned to do, and then they never did them, but they had 40 LLCs that they paid for and had to reckon with. So plan strategically, but don't overbuy. And again, I say this as someone whose firm sells these things. Don't overbuy because there's a good chance that you'll have to shut them down in a few years if plans don't come to fruition. So plan ahead, plan for the future, but execute in phases as you need to. That way you've got the LLCs you need when you need them. These aren't a scarce commodity that are going to run out. They're not like liquor licenses. You can make a new LLC when you need one. So And last but not least, use your resources. Again, everyone's situation is unique to them. It's very important to have a well thought out business structure that considers all of your different needs, the business you're doing, and your priorities. Reach out to the SBDC, www.nmsbdc.org. Really make use of that no-cost business counseling. I mean, I do not provide no-cost counseling or consultation. So the fact that the SBDC does, it is just a great resource for you. And they have such a good network of contacts within the New Mexico community that they can certainly help to point you in the right direction. So do we have any last questions?
We do
wrap up?
not. I gave a call for questions, and we have a thank you so much, Ian, because people are always looking for information on this topic. So I'm glad that you gave it to us today. Remember, like Ian said, New Mexico Small Business Development Center, we're here to help you every step of the way. That's what we do. We want to thank everyone for coming today. Remind you to check out our website because we have a whole bunch of upcoming live webinars on the books. So with all that, if there's no more questions, thanks everybody. You guys have a great rest of your day. Thanks,
Thank you all.
Ian.
Thanks.